Welcome back to the courtroom. Today we're diving into two jaw-dropping cases straight from Michigan, where courtroom rules collide with human emotion and self-representation takes center stage. First up, Alexis Brown, 33, charged with assault or assault and battery, takes a path most defendants would never dare, representing herself. Already, we see multiple missed court appearances, a warrant for her arrest, and a courtroom dynamic that's equal parts confusion and drama. But it doesn't stop there. She questions her own arrest, believes her rights were violated, and faces a judge who must carefully balance fairness without giving legal advice. Will her choice to go solo backfire? And later, we'll see an eviction case that spirals into a clash over financial obligations, missed deadlines, and courtroom etiquette. Stay tuned as we break down each shocking moment, reveal the legal truths behind the drama, and ask the tough questions. What would you do if you were in these defendants' shoes? Buckle up, this is going to be a wild ride through the rules, risks, and high-stakes drama of real courtroom proceedings. On May 19, 2025, prosecutors filed a criminal complaint for assault or assault and battery against 33-year-old Alexis Brown in the 14A District Court in Washington County, Michigan. Ms. Brown was ordered to appear for an arraignment and pretrial hearing scheduled for June 18, 2025. Ms. Brown did not appear in court, and a so-called show cause hearing was scheduled for July 2, 2025. However, Ms. Brown also did not appear for the show cause hearing and a warrant was issued for her arrest. Ms. Brown was taken into custody and on July 14, 2025, she appeared in court for her arraignment. Because she had not made bond, Ms. Brown remained in custody after probable cause was found at the arraignment. On July 17, 2025, the Washington County Office of Public Defender entered an appearance to represent Ms. Brown as her defense counsel. On the date of the hearing, Assistant Public Defender Lauren Pern was available to represent Ms. Brown, but she declined her assistance, choosing to represent herself instead. Court's the case of the people versus Alexis Brown. Good morning, Assistant Defender Lauren Perry. On behalf, well, not on behalf of Miss Brown. You know, we are an attorney of record on this case. When I did a meet with Miss Brown, she informed me she wants to represent herself. Your name? Alexis Brown. All right. Is that correct that you want to represent yourself? Yes, it is. All right. So in this matter, Brown, I do have to inform you that the complaint in this case alleges owner about June 8, 2024 location of 30001, Woodland Hills Drive in Pittsfield, Washington County, State of Michigan that you did to commit the offense of assault and or assault battery against LaTosha Browning. Do you understand what you're charged with? Yes, I do. That is a misdemeanor punishable by 93 days in jail, $500 fine plus court cost. Do you understand the maximum penalties? Yes, I do. There are certain things that are fraught in self-representation and in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand if you would like to represent yourself that you would be held to the same standard as any other attorney. MHM. The court will not be assisting you in any fashion whatsoever. You understand that? Okay. So, the time that I served, don't that counts for the 93 days? I'm sorry. The time that I served already, don't that counts for the 93 days? I don't know how much time I served 30 days already. Then if you served 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond? And then no contact with the victim as well. And the monetary amount 5,010%, then it should count. Yes, And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you was your rights when you arrested me? Well, not you, but the officer. I cannot. You can't do that with nobody right now. I just want to state that. I can't answer that. I just want to state it. All right. Okay.
Calls the case of the people versus Alexis Brown.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. We are the attorney of record on this case. When I did meet with Ms. Brown, she informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Brown, I do have to inform you that the complaint in this case alleges that on or about June 8, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation, in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you,
I served 30 days already.
and if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim as well.
And the monetary amount? 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
I
All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay.
Stated.
It's on record, right?
Ms. Brown.
17th, 2025 at 9 a.m. Reselection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
yeah, I know, but they're all by Kearney. The whole
That's-
McDonald's thing and then this. And
This-
Here's where things get really interesting. Alexis Brown is attempting to represent herself, a move that rarely ends well in real-world courtrooms. She's already in custody, missed multiple hearings, and now is questioning her arrest because she wasn't read her Miranda rights. But here's the legal reality. Simply not being read your rights at arrest does not make an arrest invalid. Miranda only comes into play during custodial interrogation. So, Alexis is actually misunderstanding a fundamental point of criminal procedure, something a defense attorney would have clarified immediately. And this is the perfect example of the risks of self-representation. The judge cannot give her substantive legal advice without compromising impartiality. He must carefully balance informing Alexis of the procedures without tipping the scales in her favor, a delicate tightrope walk. Now watch how this plays out. Alexis asks questions about bond, prior jail time, and her rights, all while navigating complex legal language and deadlines on her own. You can literally see the tension in the courtroom. She wants guidance, she wants clarity, but the law doesn't allow the judge to bend rules for her. It raises a broader question for the audience. If you were in her shoes, would you risk self-representation knowing the stakes? And notice the emotional weight here. This isn't just legal theory, it's real consequences. Potential jail time, fines, and a criminal record. The courtroom isn't a place for assumptions, it's a procedural minefield. Alexis's misunderstanding of the law, coupled with her choice to go it alone, dramatically heightens the stakes and makes every statement she makes potentially pivotal in the case. This is exactly why courtroom procedures are designed the way they are and why attorneys exist, to navigate this minefield with precision and protect their clients' rights. It's intense, it's dramatic, and it's a cautionary tale for anyone thinking about self-representation.
Carson, you can remove your hat. This is the court proceeding. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You made was there a demand?
In written, I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. I did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
No,
don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom and you will not talk over people. You will present the evidence. I am absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I
run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding. Because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do
speak?
you understand that? Yes, you may.
Well, we tried to tell her, like, the funds, we can pay them. Like, we have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor.
And
I asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself. I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtor's exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I have seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially, but I've received, like, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand.
Then I guess I misunderstood. That goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language, you have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not gonna, the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry.
I'm sorry.
I asked him if he had any of the documents that there were, in addition to information, it was documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date, and you need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her fax.
Don't tell me what to do. Don't tell me what to say. You instruct yourself.
I'll pay her in full.
You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity. I'm now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady. That might work with the lady sitting next to you. But you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number is on all of the court paperwork. You can give me a call and I'll give you a number.
Give me a new date.
September 4th at 1:30.
September 4th at 1:30, you said? Yes, in person at the court. If you pay in full, you can provide evidence of that and have this removed from my docket. Any additional matters for the record?
No, Your Honor, thank you very much.
Save the tax and money.
Mute him and remove him from my courtroom before he's in contempt. Mute him and remove him from my courtroom before he's in contempt.
So, what do we take away from these two cases? In Alexis Brown's case, self-representation led to confusion, legal misunderstandings, and potentially avoidable risk. Questions about Miranda rights, bond, and trial type showed the immense value a skilled attorney brings, someone who can guide a client through procedural nuances, safeguard rights, and ensure deadlines aren't missed. Meanwhile, in the eviction case with Mr. Carson and Ms. Wilson, we saw similar lessons: failure to follow procedural requirements, missing deadlines, and misunderstanding of appeal rights left them exposed. The judge had to manage both the legal correctness of the proceeding and the emotional dynamics in the room, balancing fairness with firmness. These cases highlight a broader point. Courtroom procedures are technical for a reason, and self-representation carries serious risks, particularly in criminal and financial disputes. Understanding your rights, meeting deadlines, and having proper legal counsel can literally be the difference between losing and protecting your interests. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. By following these cases, we can all become more informed about legal realities, procedural nuances, and the consequences of navigating the justice system without guidance. Stay tuned, stay informed, and remember, the courtroom is a place of rules, rights, and real consequences.